The title office hummed with fluorescent lights and shuffling papers. I sat in a plastic chair waiting for my father to finish signing documents. The closer was a tired woman in her 50s who kept straightening her stack of forms. I glanced at the settlement statement lying on the table. My eyes caught one line that made my face go hot. Buyer's agent, Luke Porter. My husband. My husband was the agent handling the sale of our family farm. The farm my grandmother had left to us. The farm I'd grown up on. The closer blinked at Luke's disclosed conflict of interest form lying beside the contract. She cleared her throat uncomfortably. "I'll need the full legal description and the complete contract packet," she said to my father. He nodded casually like this was routine business. Like selling a 100-year-old farm was the same as trading in a car. I felt my phone vibrate in my pocket but didn't move. Just sat there staring at my husband's name in black ink on official paperwork. The title hit me in waves. My name is Whitney Hale. I'm 34 years old. I work at the county farm cooperative managing purchase orders and vendor contracts. I've lived in this rural community my entire life. The farm we were sitting here selling had been in my family for 4 generations. My grandmother had raised cattle there. My father had grown wheat. I'd learned to drive a tractor in those fields before I could legally drive a car. And now it was being sold to some conservation group without anyone asking me. I pulled out my phone under the table. Texted myself 3 words, record everything. Don't react. I forced my face to stay neutral. Calm. Like I didn't care. Like this wasn't ripping my heart out. Then I saw the parcel number on the settlement statement. Parcel number 17-043-A. The exact same number from my grandmother's original deed. The deed I'd seen in her cedar chest years ago. Last July we'd had a family cookout under the cottonwood trees. My father had announced his plans to modernize the farm operation. Said he wanted to subdivide the back 40 acres. Sell them off to developers or conservation buyers. My brother Cole had grinned widely. Talked about the money we'd all make. How we could finally invest in something profitable instead of wasting time on dirt and cattle. I'd asked careful questions about soil classifications. About water rights. About the implications of subdividing agricultural land. My father had waved me off like I was a child asking silly questions. Don't worry about details, Whitney. This is business. Cole had laughed. Said I was too sentimental about dirt. That night my grandmother had pulled me aside. She was 91 then. Still sharp as ever. She'd whispered in my ear while leaning on her cane. The original deed lives in my cedar chest. You should look at it carefully. She'd squeezed my hand. Died 2 months later. I'd never gotten around to checking that chest until now. My desk at the farm cooperative was covered in spreadsheets and delivery schedules. Purchase orders for seed. Vendor terms for fertilizer. Calendars marking planting and harvest windows. I could feel my hands finally stop shaking. The title office had been 3 hours ago. I'd driven straight to work afterward without saying anything to my father or Luke. Now I sat alone in my small office and pulled up the county recorder's website. The portal was clunky. Old government software that barely worked. But it had every property deed ever filed in our county. I typed in the parcel number. 17-043-A, hit search. Waited while the page loaded slowly. Finally the original deed image appeared. My grandmother's deed from 1967. I zoomed in and read every word carefully. Looking for anything that would explain why this felt so wrong. Why my gut was screaming that something illegal had just happened. Then I found it. A clause everyone had apparently forgotten existed. The clause was written in old legal language. Dense and formal. But the meaning was clear once I read it 3 times. Right of first refusal in favor of lineal heirs. Any sale of the property required 30-day written notice to all direct descendants. Those descendants had the right to match any legitimate offer. The notice had to be sent by certified mail with delivery confirmation. I sat back in my chair. Stared at those words. Right of first refusal. I was a lineal heir. My grandmother's granddaughter. The property couldn't legally be sold without giving me a chance to buy it first. I pulled up my email. Searched for anything from my father or his attorney. Nothing. Checked my physical mail logs. Nothing certified. No legal notice. No opportunity to exercise my rights. My father had sold the farm without telling me. Without following the deed requirements. Without giving me any chance to preserve what my grandmother had built. The sale wasn't just wrong. It was potentially illegal. And my husband had been the agent handling it. Luke came home that evening looking exhausted. We'd been married for 6 years. He was a good man. Honest. Ethical about his real estate work. He met me on our front porch before even going inside. His face was drawn. Guilty. They called me 4 months ago, he said immediately. The Prairie Land Conservancy. Looking for an agent to represent them on a farmland purchase. When I saw the parcel number, I recognized it immediately. Told them it was your family property. Disclosed the conflict of interest in writing. They said they still wanted me because I understood agricultural land. His voice cracked slightly. I couldn't give you non-public information about the sale, Whitney. That would be illegal. I was bound by client confidentiality. He pulled a folded paper from his jacket. Handed it to me. It was the public notice of sale. Filed with the county 2 months ago. Perfectly lawful procedure. Available to anyone who checked public records. I thought your dad had told you, Luke whispered. I really thought you knew. I looked at the man I'd married and saw the pain in his eyes. He'd been trapped between professional ethics and family loyalty. And he'd chosen the law. I hired an attorney the next morning. Her name was Ms. Dalton. She specialized in farm and real estate law. Had an office above the hardware store downtown. She was in her 60s with steel gray hair and sharp eyes that missed nothing. I spread out everything on her conference table. Grandmother's deed. The settlement statement. The public notice of sale. The parcel records. She put on reading glasses and examined each document carefully. Made notes on a yellow legal pad. The right of first refusal is enforceable, she said after 30 minutes. It runs with the land. Transfers to all subsequent deed holders. Your father was required by law to send certified notice to all lineal heirs 30 days before closing. Did you receive such notice? I shook my head. She smiled without any humor. Then we have grounds to challenge the sale. She pulled out fresh paper and started drafting. A notice of intent to exercise right of first refusal. Ready to file with the county recorder. Ready to stop everything my father thought was finished. This will get complicated, Ms. Dalton warned. Family cases always do. We went to the post office that afternoon. I requested a complete mail history for my address going back 6 months. The clerk printed everything. Every piece of certified mail. Every delivery confirmation. Every registered letter. I scanned through the stack carefully. Nothing from my father. Nothing from his attorney. Nothing from any seller regarding the farm property. The required legal notice had never been sent. Ms. Dalton made copies of everything. Added it to our growing file. This strengthens your position considerably, she said. They can claim they sent notice, but we have proof you never received it. The burden is on them to prove proper service. She started drafting another document. A lease pendens. A legal notice that there was a dispute over the property. It would attach to the title. Make it impossible for anyone to claim they bought the land without knowing about the conflict. We file this with the county recorder, she explained. It clouds the title. Makes the sale vulnerable to being unwound. I thought about my father's face when he found out. About Luke caught in the middle. About Cole's anger. Then I signed my name at the bottom. Some things were worth fighting for. I drove to the county water master's office the next day. It was a small building near the courthouse. The water master was an older man named Mr. Peterson who'd held the position for 30 years. He knew every water right in the county by heart. I asked about our farm parcel. About the water rights attached to the north pasture. He pulled up old files. Showed me a certificate of water right from 1958. This is a senior right, he explained. Very valuable. Any transfer of water rights requires specific filings with this office. The new owner has to demonstrate continued beneficial use. Usually agricultural use. He checked his recent filings. Frowned. I don't see any transfer application for your parcel. If the land's sold, the water rights should have been formally transferred. That's a required closing condition for agricultural property. I felt something click into place. Ms. Dalton had told me to look for unmet conditions. Technical requirements that might invalidate the sale. The water rights hadn't been properly transferred. Which meant the closing wasn't actually complete. We had another opening to challenge everything. The county assessor's office was my next stop. I knew the farm had special tax status. Reduced property taxes because of agricultural use. But I needed to understand the details. The assessor was a woman named Mrs. Chen. No wait, Mrs. Morrison. No. Mrs. Hayes. She pulled up our parcel information on her computer. Your family farm is enrolled in the agricultural current use program, she explained. It gets reduced tax assessment based on farm income rather than market value. Saves thousands of dollars annually. She clicked through more screens. But there's a catch. If the property sells and stops being used for agriculture, there's a recapture tax. The county bills for all the tax savings from the past 10 years. It can be a substantial amount. I asked if the recent sale had triggered recapture. She checked the paperwork filed with the deed. The buyer needs to file a continued agricultural use affidavit within 30 days of closing, proving they'll maintain farm operations. Without that affidavit, recapture is automatic. She looked up at me. I don't see any affidavit filed yet. Your father might be getting a very large tax bill soon. The kitchen fight happened 3 days later. My father called demanding to know why I'd been snooping around county offices. Why I'd hired an attorney. Why I was making trouble over a business decision that was none of my concern. It's my land, he said coldly. I can do what I want with it. I pulled out my grandmother's deed. Laid it on the kitchen table between us. Pointed at the right of first refusal clause. It isn't just yours, I said quietly. Grandma made sure of that. You were required to give me notice. 30 days to match any offer. You sold it without telling me. Without following the deed requirements. My father laughed. Actually laughed. I already sold it, Whitney. It's done. The money's in the bank. You're too late. I slid the notice of intent across the table. The document Ms. Dalton had prepared. Not according to the law. The sale violated my rights. We're filing this with the county tomorrow. His smile disappeared. Replaced by something darker. You would sue your own father? I met his eyes. You sold my inheritance without asking. The air felt heavy between us. Years of being dismissed. Of being called too emotional. Of being treated like my opinions didn't matter. All of it crystallized in that moment. We filed everything the next morning. The notice of intent to exercise right of first refusal. The lease pendants claiming a dispute over the property. Ms. Dalton walked the documents to the county recorder's office personally. Made sure they were filed and stamped before noon. Within an hour, phones at the title company started ringing. The closer who'd handled the original sale called Ms. Dalton in a panic. We need to put a hold on disbursement, she said. There's a cloud on the title. We can't release funds until this is resolved. Ms. Dalton calmly explained that the sale had proceeded without proper notice to all required parties. That the right of first refusal had been violated. That my client intended to exercise her legal rights to match the purchase price. The closer groaned. This is going to be a mess. She sent an email within the hour. A formal hold on the closing pending clearance of the title dispute. My father's money stayed frozen. The Prairie Land Conservancy's ownership stayed in limbo. Everything stopped. Just like that, the finished sale became unfinished. The Prairie Land Conservancy's director called me that afternoon. His name was Mr. Bennett. He sounded worried but not angry. Miss Hale, we received notice of your challenge. I want you to know we didn't know about the right of first refusal clause. Your father and his attorney assured us clear title. We're a nonprofit organization focused on preserving farmland. We support keeping agricultural land in the hands of farmers. His voice was genuine. We're not trying to take your family's heritage. If you have a legal right to purchase the property, we'll respect that. We'll cooperate with any court schedule. I felt some of my anger ease. The Conservancy wasn't the enemy here. They'd been misled just like me. I appreciate that, I said carefully. My goal is to keep the farm operating as a farm. Which seems to align with your mission. We talked for 20 minutes. By the end, I understood their vision. Conservation easements. Preserving agricultural land. Preventing development. It wasn't so different from what I wanted. Luke recused himself from any further conversations that weren't documented in writing. His broker required it. He was my husband at home but a neutral professional in this dispute. The courtroom was smaller than I expected. Wood paneling and fluorescent lights. A judge who looked tired before the hearing even started. Ms. Dalton presented our case methodically. The deed with the right of first refusal clause. The lack of certified notice. The proof from the post office. The statutory requirements for proper service. My father's attorney argued it was a technicality. That I'd known about the farm's sale through family channels. That I'd waived my rights by not objecting sooner. The judge listened to both sides without expression. Then he picked up my grandmother's deed. Read the clause aloud. Right of first refusal to lineal heirs. 30-day notice by certified mail. He looked at my father's attorney. 30 days means 30 days. Certified mail means certified mail. Was proper notice sent to Ms. Hale? The attorney shifted uncomfortably. We relied on informal family communication. The judge's eyebrows raised. That's not what the deed requires. He ordered notice reserved to all lineal heirs properly. Paused the closing until the 30-day window completed. Set a status hearing for 6 weeks out. My father's mouth tightened into a hard line. I just bought myself time. The money problem hit me immediately. Matching the purchase price meant I needed substantial funding. I brought spreadsheets to Ms. Dalton's office. My salary from the farm cooperative. My savings account. A modest line of credit from the credit union. All of it together wasn't enough for the full purchase price. Not even close. I felt hope starting to drain away. I'd fought this hard just to prove I couldn't afford it anyway. Then Mr. Bennett from the Prairie Conservancy called with a proposal. We've been thinking about this situation, he said. What if we structured something different? The Conservancy takes title with a permanent preservation easement. No development ever. Agricultural use only. Then we ground lease the property to you. You'd have an option to purchase the house and barns over time. He explained the numbers. The ground lease would be affordable. Based on farm income. The option price would reflect the easement restriction. Much lower than market value. You'd control the land, he said. Farm it however you want. We'd just ensure it stays farmland forever. I felt my throat tighten. It wasn't perfect ownership. But it was keeping the farm in the family. Keeping it operating. Honoring what my grandmother had wanted. Luke stayed completely separated from the negotiations. His broker had required written disclosures to everyone. The Conservancy allowed him to remain as their buyer's agent only for public filings. Nothing confidential. Nothing strategic. At home, he'd look at me across the dinner table and say carefully, "I'm your husband in our kitchen. But I'm their fiduciary in that office. I can't discuss anything that isn't public record." It created a strange tension. We'd eat meals in near silence. Both knowing what was happening but unable to talk about it. He'd go to bed early. I'd stay up late reviewing documents with Ms. Dalton. We existed in parallel worlds that couldn't touch. But I understood. Luke was protecting his license. His career. His professional integrity. He'd already disclosed more than most agents would have. I couldn't ask him to cross ethical lines even for family. Ms. Dalton drafted the ground lease agreement. The purchase option for the improvements. The agricultural use requirements. All the technical language that would make this complicated arrangement legally binding. We were building something new from the wreckage of my father's betrayal. My father tried one last move. At the 11th hour, he filed paperwork trying to carve out the barns from the sale. Claimed they were separate improvements not included in the original deed. The title company demanded a new legal description. New surveys. New documentation. Each delay cost money. Cost time. The assessor calculated that any change to the property configuration would trigger the recapture taxes. The bill was substantial. Over $40,000 for 10 years of reduced agricultural assessment. My father would owe it personally if the farm stopped qualifying for current use. His face went pale when the assessor's letter arrived. He'd never considered that consequence. Never thought through what subdividing or changing use would actually cost. He'd seen the sale price and gotten greedy. Now that greed was costing him thousands. The barn carve-out idea died quickly. Even his attorney advised against it. Too expensive. Too complicated. Too likely to trigger more problems. The property would sell as one complete parcel or not at all. Cole showed up at my apartment one evening. My brother who'd grinned at that cookout. Who'd called me too sentimental. Who'd never thought I'd actually fight back. He had a take it or leave it offer. "Walk away from this whole mess," he said. "Let the sale go through. Dad will let you rent a corner of the property. You can have a little garden. Keep some chickens. Everyone wins." I looked at him. This man I'd grown up with. Who'd never understood why I cared about dirt and cattle and water rights. I pulled out a copy of the judge's order. The one requiring proper notice. Pausing the sale. Protecting my rights. "The judge says I have a legal claim," I said quietly. "Why would I walk away from something that's mine?" Cole's face darkened. "You were never built for this kind of fight, Whitney. You don't have the spine for business." His words were meant to hurt. To make me doubt myself. I thought about all the purchase orders I'd negotiated. All the vendor contracts I'd managed. All the complicated logistics I handled every day at the cooperative. "Maybe you never paid attention to what I was built for," I replied. He left angry. I didn't care. The independent appraisal came back lower than my father expected. The preservation easement reduced the property value significantly. No development potential. Agricultural use only. Permanent restrictions on what could be built or changed. The appraiser valued the land based on farm income rather than potential subdivision sales. My father had been bragging about the sale price for months. Now the math showed he'd overestimated by almost 30%. He called the appraiser. Called the Conservancy. Called anyone who would listen. Complained that the numbers were wrong. But math doesn't care about feelings. The preservation easement had a real economic cost. Lower value. Restricted use. That was the whole point. The Prairie Conservancy signed the final purchase addendum. Subject to my right of first refusal being properly exercised. Subject to the ground lease and option being executed. Subject to all the complicated pieces finally falling into place. We were close. So close I could almost feel the dirt under my boots again. Could almost smell hay in the barn. Could almost hear cattle in the pasture. We filed my formal election to match during the 30-day window. Ms. Dalton hand-delivered it to the court. To the title company. To my father's attorney. To everyone involved. I wired earnest money from my credit union account. Proof I was serious. Proof I had some funding in place. That night Luke and I sat at our kitchen table eating cold pizza at 11 o'clock. We didn't talk about the case. Didn't talk about the farm. Just sat together in exhausted silence. Both too tired to do anything but exist in the same space. His phone buzzed. He glanced at it and sighed. Title company, he said quietly. They're preparing a revised settlement statement. Checking all the agricultural use boxes. Making sure every requirement is documented. We locked eyes across the table. This was really happening. After months of fighting. After destroying family relationships. After spending everything I had on attorneys and filing fees. The farm was coming back. Not the way I'd imagined. Not with simple ownership. But coming back to family control nonetheless. The status hearing was brief. The judge reviewed everything filed since the last appearance. Confirmed that proper notice had now been served. That I'd filed my election to match within the required window. That funding was in place through the conservancy structure. The right of first refusal has been properly exercised, he ruled. The closing may proceed with Ms. Hale's interests preserved through the ground lease and option agreement. He looked at my father. The original sale is modified but will close as restructured. All parties will comply. My father stared through me like I didn't exist. Didn't speak. Didn't acknowledge my presence. Just stood there radiating anger. Cole wasn't even in the courtroom. Had stopped coming to hearings weeks ago. The Prairie Conservancy's director caught my eye. Nodded slightly. An email arrived on my phone minutes later. We'll see you at the closing table. Together this time. Looking forward to preserving this land with you. I felt something release in my chest. The validation I'd been fighting for. Recognition that I wasn't crazy. That this mattered. That my grandmother's legacy deserved protection. The closing was strange and quiet. We sat around a conference table at the title company. The Prairie Conservancy took official title with the preservation easement recorded. Then immediately executed my ground lease. 99 years. Agricultural use required. Rent based on farm income. They signed the purchase option for the house and barns. Giving me the right to buy the improvements over time. The water rights assignment was filed showing continued agricultural use. Everything checked. Everything documented. Everything legal. Luke witnessed signatures as the buyer's agent. His eyes were wet. He'd maintained his professional obligations throughout. But I could see the relief on his face. The unbearable tension of being caught between family and ethics was finally over. The clerk stamped everything with a hollow thud. Official county seals. Recorded deed. Recorded easement. Recorded lease. The farm that had been sold without asking me was now protected. Now in my hands to steward. Now safe from development forever. The closer handed me a thick folder. Copies of everything. I held it like it was precious. Because it was. It was my grandmother's dream preserved in legal paperwork. The consequences landed hard on my father. The assessor issued the recapture tax bill. Over $40,000 for the agricultural use exemption he'd enjoyed for years. Due immediately. His backup buyer had disappeared once word spread about the title dispute. No developer wanted property with a preservation easement. No investor wanted land that could only be farmed. The money he'd been counting on evaporated. The title company sent him a detailed letter explaining why funds were being held and redistributed according to the modified agreement. He'd get less than he'd planned. Much less. After attorney fees and the recapture tax, he'd barely break even. He called my phone once. I let it ring. Didn't answer. Didn't call back. Some bridges burn completely. Some relationships can't survive betrayal. I tried to talk to him before the sale. Tried to be included. Tried to preserve family unity. He'd chosen money over his daughter. Now he could live with that choice. I was done begging for scraps of respect from people who'd never valued me anyway. The first Saturday back on the farm felt surreal. I walked into the barn. Hung a clean halter in the tack room. The space smelled like hay and motor oil and dust. Smells I'd grown up with. Smells that meant home. I'd organized a free pasture walk for local kids. Teaching them about sustainable agriculture. About soil health. About why farmland mattered. About 15 children showed up with parents. I showed them how to check a fence staple. How to read soil by rubbing it between your fingers. How to identify different grasses. How to understand why this land was worth fighting for. Mr. Bennett from the Prairie Conservancy came. Shook my hand. Told the families about preservation easements. About protecting agricultural heritage. Then he left quietly. Let me have this moment without his presence looming. Cole drove past slowly on the county road. I saw his truck. Saw him looking at the children in the pasture. At me teaching what our grandmother had taught me. He kept driving. Didn't stop. Didn't wave. Just watched what he tried to take away and kept going. Maybe someday we'd talk. Maybe not. I'd made my peace either way. I unlocked my grandmother's kitchen door. The robin's egg blue paint was faded but still beautiful. The house was empty. My father had taken all his furniture when he moved out. But the bones were good. The structure was solid. I set fresh notebooks on the kitchen table. Started planning. Grazing rotation for the pasture. Crop schedules for the fields. Class sign-ups for agricultural education. Business projections for the ground lease payments. Everything I'd need to make this work. To honor what my grandmother had built. To prove I could steward this land properly. I didn't wait for an apology that would never come. Didn't waste energy hoping my father or Cole would admit they'd been wrong. Some people never see their own cruelty. Never understand what they destroyed. I'd learned the hard way that if someone sells your roots without asking, you have to know the paperwork. Use the legal system. Fight with facts instead of emotions. Grow the field anyway under your own name. By the book. For the children who will inherit your rows. My grandmother had left me more than land. She'd left me a roadmap written into that deed. And I'd followed it all the way home.